Kasolo Compuliyamu, and Kasolo appears for F3, 4 and 5.
Court. This case is between Uganda for the prosecution versus Kasolo Compuliyamu alias Arsenal, Rebecca Johnson alias Fido, alias Eto, alias Manumano, alias Rasta, 3 Kaliango Nasif alias Mwonge, Chiseka Hassan alias Masada Mpanga Sharif alias Shafik, Katerega Sadat alias Barrows. The accused persons are each indicted on 2 counts of kidnap with intent to murder under section 243 subsection 1A of the Penal Code Act, 2 counts of murder under section 188 and 189 of the Penal Code Act, and 2 counts of aggravated robbery under section 285 and 286 subsection 2 of the Penal Code Act. It was alleged in count 1 that the accused person is on 28th day of August 2019 at Nabisasiro Zone, Rubaga Division, Kampala District, with intent to murder, forcefully kidnapped Nagirinya Maria Gaten. It was alleged in count 2 that the accused person is on the 28th day of August 2019 at Nabisasiro Zone, Rubaga Division, Kampala District, with intent to murder, forcefully kidnapped Kitayimbwa Ronald. Is alleged in count 3 that the accused person is on the 28th day of August 2019 within the areas of Kampala and Mukono district with the malice aforethought killed Nagirinya Maria Gaten. It is further alleged in count 4 that the above mentioned accused person is on the 28th day of August 2019 within the areas of Kampala and Mukono with the malice aforethought killed Kitayimbwa Ronald. It is also alleged in count 5 that the accused person is on the 28th day of August 2019 within the areas of Kampala and Mukono district robbed Nagirinya Maria Gatenyi of her motor vehicle registration number UBA 570V Spacio white in color, mobile phone IME number 362953044557610, and cash 260,000 shillings, and at or before or after the time of the robbery caused the death of Nagirinya Maria Gaten. It is further alleged in count 6 that the accused person is on the 28th day of August 2019 within areas of Kampala and Mukono district robbed Kitayimbwa Ronald of his mobile phone Nokia serial number 3568399092, another 092020, and cash 24,000 shillings, and at or before or after the time of the robbery caused the death of Kitayimbwa Ronald. Our representation, A1 Kasolo Compuliyamu alias Arsenal, opted to waive his rights to legal representation and chose to represent himself. A3 Kaliango Nasif, alias Mwenge, A4 Chiseka Hassan alias Masada, and A5 Mpanga Sharif alias Sharif were represented by Counsel Serwanga Geoffrey, while A2 Rebecca Johnson alias Eto and A6 Katerega Sadat alias Barrows were represented by Counsel Serwambala Julius Caesar. The prosecution was represented by Chief State Attorney Mwanga Timothy, Mwaganya Jonathan, and Senior State Attorney Counsel Timothy Amerit. The burden of proof in criminal cases, the prosecution has the burden of proving the case against the accused persons beyond reasonable doubt. The burden does not shift to the accused person. See the case of Wilmington versus DPP. Proof beyond reasonable doubt does not mean proof beyond a shadow of doubt. The prosecution evidence should be of such standard as leaves no logical explanation to be derived from the facts, except that either the accused committed the offense or is innocent. I mean, depending on what the case ends up, how the case ends up. The accused person should therefore only be convicted on the strength of the prosecution case and not the weaknesses in their defense. All the accused persons were found to be of normal mental state. And now, I will proceed to resolve the matter. The offense of kidnapping with intent to murder, according to Section 243, subsection 1A of the Penal Code Act, for it to be proved, the following ingredients had to be proved by the prosecution beyond reasonable doubt. One, that there was the taking away of a person or persons in this case. Two, that the taking away was accomplished by force or fraud. Three, that the taking away was against the victim's will. And four, that the perpetrators of the offense were motivated by an intent to murder the victim or victims. And that the accused persons were the perpetrators of the said offense. Now, the element of kidnap or taking away a person, kidnap may be defined as the taking away or transportation of a person against that person's will, usually to hold that person in false imprisonment or confinement without legal authority. This may be done for a ransom or in furtherance of another crime. There is a case of Uganda versus Musmami and two others to that effect. To prove this ingredient, the prosecution relied on the evidence of Senabulia Isaac alias Kisunsu, that was PW 9, who testified that they found the motor vehicle of Nagirinya Maria Gatene at the gate, hooting and about to enter inside the gate. He said that he found A1 and A2 who had been moving with him already inside the vehicle, and he also joined them inside. He said that inside the car was a male and female occupant. He further stated that they laid down the occupants in the rear seats of the vehicle and they drove the vehicle away from the gate. It was also the evidence of PW9 that the occupants in the vehicle were pleading with them to tell them the reason why they had captured them, but the police failed. Their pleas were ignored. Later, their bodies were recovered from Nachitulu Valley, Lokojo Village, Mpoma Parish, Nama Sub-County in Mukono. I find that this evidence is sufficient to prove that the victims were kidnapped. They were taken away, and later they were found to be dead. Whether the kidnapping was by force and against the will of the victims, taken away by force and against their will, that they forced them to sit in the rear seat of the motor vehicle and drove away from the gate. He also told the court that the victims pleaded with them, but their pleas were not heeded. The fact that the victims were later found dead implies that they were taken by force and against their will. This fact was not disputed. I find that the prosecution proved that the victims were taken against their will, and the same was done by force. I will now also address those two elements. Whether the perpetrators of the kidnap were motivated by an intent to murder the victims, the intent to kidnap and murder may be inferred from the fact that the victims were found murdered. In this particular case, PW1 and PW2, the medical personnel, gave evidence to the effect that the victims were brutally murdered. This evidence was corroborated by PW9, testifying that the victims were murdered using a log and a car jack. The eventual murder of the victims is sufficient proof that there was intention to murder them. Now, the aspect of participation shall be handled together for all the counts. Now, moving on to count 3 and 4. Murder. The offense of murder is said to be committed where any person who, with the malice aforethought, causes the death of another person by an unlawful act or omission. The following ingredients must be proved beyond reasonable doubt. 1, that there was death of a human being. 2, that the death was caused unlawfully. 3, that the death was carried out with malice aforethought. And 4, that the accused person is participated in the commission of the offense or are responsible for the death. The element of death of a human being. Death of a human being may be proved by production of a post-mortem report or evidence of witnesses who state that they knew the deceased person and attended the burial, also the dead body. This was held in the case of Uganda versus Mwesigwa, Jamada, and 3 others. The prosecution relied on the evidence of PW1, Dr. Moses Biaruhanga, a forensics pathologist, and a director of health services in the Uganda Police Force, who testified that the deceased was identified by Dr. Ben Chuanuka, the uncle of the deceased. He testified that he examined the body of the deceased on the 31st of August 2019 in detail. This county is in respect of Nigeria only. He testified that he examined the body of the deceased on the 31st of August 2019 in detail. PW described the injuries which were on the body of Nagirinya. He stated that the cause of death was neurologic shock following blunt head trauma. The post-mortem report was exhibited in the court as Exhibit P1. The prosecution also relied on the evidence of Dr. William Male Mutumba, that's PW2, a pathologist, to prove the death of Ronald Kitayimbwa. He told the court that he examined the deceased, Kitayimbwa Ronald, on the 1st September 2019, and his body was identified by one Lubega Robert, a brother to the deceased. He found that the deceased person died as a result of head injury due to blunt force trauma. The post-mortem report was tendered in court as Exhibit 2. PW4, the Lord Francis Anthony, the biological father of Nagirinya, Maria Gaten, also confirmed that Nagirinya Maria had been killed. Catherine Rollins, PW5, equally testified that Kitayimbwa Ronald had been killed and he was buried. So that was enough evidence to show death. The prosecution proved the death of Maria Nagirinya and Kitayimbwa Ronald beyond reasonable doubt as to whether death was unlawfully caused. In a homicide, that is the killing of a human being by another, is presumed to have been caused unlawfully unless it was accidental or was authorized by law. You see the case of R versus Gusambizi, son of ensonga. To prove that the death was caused unlawfully, the prosecution adduced the testimony of Senator Isaac Elias Kisunsu, PW9, who testified that when they had reached at the scene of crime in Mukono along with A1, Kasolo Compuliyamu, and A2, Lubega John Manomano, A1 opened the doors of the car and picked out Nagri and hit her with a car jack on the head. It was also the evidence of PW2 that A2 brought a big log and gave it to A1, who beat Kitaibwa with it. The prosecution also adduced evidence of the post-mortem report of Nagiri Maria tendered in by Dr. Yaruhanga Moses, which indicated that her death was caused by neurologic shock following blunt head trauma, and the post-mortem report of Kitaimbwa Ronald tendered in by Dr. Miriam Male Mutumba indicates that he died as a result of head injury due to blunt force trauma with considerable magnitude given the nature of the injuries. Each of the post-mortem reports clearly indicate the diverse injuries sustained by each of the deceased persons on their heads. This corroborates the testimony of PW9. The evidence as a whole clearly shows that this was not a natural or accidental death, but a double homicide or double murder. The death was caused unlawfully, and I find that the prosecution adduced sufficient evidence to prove this beyond reasonable doubt. In addition to what is entailed by malice aforethought is settled. Section 191 of the Penal Code Act defines it either as an intention to cause death of a person or knowledge that the act causing death will probably cause the death of some person. According to the above provision of the law, the basic element in proving malice aforethought is the existence of an intention to cause death. There must be a premeditated or planned intention to cause death. In the absence of the accused person's premeditation to kill, the conviction cannot stand. Malice aforethought may be established when the harm is directed at a sensitive and vulnerable part of the body. This is because usually an attacker will not declare his intention to cause death or grievous harm. So whether or not he had the intention must be ascertained from the various factors, which include the type and size of the weapon used in the attack, leading to the death of the victim, the amount of force used by the attacker on the victim, the part of the body of the deceased where the injury was inflicted. This was restated in the case of R versus Tuvere, son of Ochen. It is an East African Court of Appeal case. Similarly, in the case of Nanyonjo Harriet and another versus Uganda, it was held that for a court to infer that an accused killed with malice aforethought, it must consider if the death was a natural consequence of the act that caused the death, and if the accused foresaw death as a natural consequence of the act. The deceased Nagirinya Maria Gaten sustained the following injuries as indicated in the post-mortem report exhibited in the court, that is Exhibit 1. She had an excessive intuition of the lips with lacerations. She also had a fractured right upper jaw with the fresh loss of 2 teeth. The report also indicated that she had a big stellate scalp laceration with a fractured skull. It was further indicated that the head and the neck had multiple fractures. The cause of death was neurologic shock following a blunt head trauma. In respect of Kitaibwa Ronald, the prosecution adduced evidence of PW2 testified that upon examining Kitaibwa Ronald's body, he found the following injuries, both internal and external. He had a depression on the skull. The right eye socket was collapsed, implying that the bones were fractured and almost inside the skull. The victim also suffered cut wounds on the face, which were bone deep. He also had laceration wounds on the forehead, which were skin deep. The victim also suffered multiple internal fractures, and the cause of death was an injury following blunt force. The nature of the injuries sustained by the victims are consistent with the evidence of PW9, who stated that the lady was hit with a car jack, while the man was hit with a log. The photo exhibits of the bodies were marked exhibit P15 and showed the extent of the injuries. A horrific, the photos of the bodies were horrific. Actually, I'm unlucky that I had a glance at them, but that was my job. So I find that the prosecution proved beyond a reasonable doubt that there was malice aforethought in causing the death of the two robbery. The following ingredients had to be proved by the prosecution beyond a reasonable doubt. One, that there was theft of property. Two, that there was use of actual violence at, before, or after the theft, or that the accused person is caused death to the victims. Then that the assailants were armed with a deadly weapon before, during, or after the theft, and then the participation of the accused persons. As to whether there was theft of property, theft occurs when a person fraudulently and with intent to deprive the owner of a thing capable of being stolen takes that thing from the owner without a claim of right. See section 254, subsection 1 of the Penal Code Act. Under section 254, subsection 1 of the Penal Code Act, the offense of theft is sufficiently proved upon proof of the fraudulent taking or conversion of any item that is capable of being stolen. In proving theft, there is no legal requirement to prove ownership. Once exportation or movement of the property takes place without the consent of the one in possession, then theft has occurred. See the case of Sulaka Sira versus Uganda. To prove theft of mobile phones and the mobile money, the prosecution relied on the evidence of PW9, who testified that before the victims were killed, they took phones from, the perpetrators took phones from Nagirinya, Maria Gateni, and Kitaimbwa Ronald, but they forced the victims to disclose the PIN codes, that is the passwords of their mobile money and Airtel MTN mobile money and Airtel mobile money accounts. That PW9 also told report that it is PW2 who went with the phones to withdraw the money. That is Mr. Johnson Lubega. He also says that PW9 also testified that later they withdrew money from the phones of Nagirinya and Kitaimbwa, and all of the accused persons shared it the following day from Ombabito in Natete. And that it was A1, okay. The theft has already been said, they stole the money and the phones and the vehicle and all that. That was the theft. The prosecution further relied on the evidence of Iga Disan, that is PW14, who stated that he is a mobile money operator. It was his evidence that on the 29th of August 2019 at around 5 a.m. while at his kiosk in Natete. A2 asked him to withdraw money from a phone. The phone in the money in the phone was 270,000, and upon conducting the withdrawal transaction, the phone of AT showed the names of Nagirinya Maria. The agent line he was using was 07082189948, and the money was withdrawn from mobile line 074970863. The names of Nagirinya, as I have said. The prosecution also relied on the evidence on the data analysis report tendered in by PW21, that is Baraza, as Exhibit 42, which indicated an Airtel money statement indicating that 260,000 shillings had been withdrawn from phone number 07049700863 on the 29th day of August 2019 at 5:55 hours to agent line 07082189948, which he later identified belonged to Disan, a money agent 14, that Igadisan also identified A2 as the person who came and withdrew that money. The prosecution further relied on the evidence of Wakubiwa Tom, PW13, who testified that on the 31st of August 2019 at about 6:24 p.m., a certain gentleman went to him and made a transaction on the mobile money. He withdrew 24,000 shillings on the line of Chitayimba Ronald, that when initiating or doing that transaction, the phone displayed the names of Chitayimba Ronald. That after completing the transaction, he gave him the 24,000. That is the PW13 is the one who gave that gentleman the money. He said that his mobile money agent number is 0704-835-744, and that the number of the customer from which the money was withdrawn was 0755-848-732. The SIM card history of Chitayimba's line, as per the data analysis report tendered by PW21, as Exhibit 42 indicated that after the crime, his phone was inserted in the phone handset number IME 135736010181734 on 1st of September 2019 at 4:36:40 p.m., during which money was withdrawn from it on the 31st August at 18:25 hours. This handset, according to the evidence of PW8 Frank Nyakairu, was recovered from Rebecca Johnson. The Airtel money statement of telephone number 0755848735 shows that 24,000 shillings was withdrawn from it on the 31st of August 2019 at 18:25 hours to agent line, which I've already mentioned above, 0704-8354-744, who were identified to be of Wokubibwa. To prove theft of motor vehicle registration number UBA 570V, the prosecution relied on the evidence of Sanabria Isaac, PW9, who told the court that on the night of 28th August 2019, they found the said motor vehicle at the gate and forcefully accessed it. and drove away with its occupants. The person who drove away the motor vehicle had no claim of right over it. Other occupants had been kidnapped. We've already found that. PW9 further stated that it was A1, Mr. Kasolo, who drove away the motor vehicle up to Mukono, where they later murdered Nagirinya and Chitaimbwa Ronald from. The printed image of motor vehicle registration number UBA 570 was admitted as exhibit P14. Detective Sergeant Barasa T. James, PW21, stated that the motor vehicle, Espacio, white in color, under registration number UBA 570, belonged to Nagirinya Maria Gateni. He also testified that on the fateful night of 28 August 20, it was Kitaimbwa Ronald who was driving the said motor vehicle, while Nagirinya Gateni was seated at the front as a passenger. Later, the vehicle was... the prosecution also relied on the evidence of SP Ogwanga Nixon, PW19, who testified that the motor vehicle in the photo admitted as XP14 was taken and captured by an ANPR, that's automatic number plate registration camera, at Chinawataka at 05226, and the motor vehicle was captured while it was being driven by a man towards Chireka. That man was identified by PW9 to be A1, that is Mr. Kasolo. PW9, remember, was unaccompanied, he was with them. PW9 told the court that the motor vehicle was abandoned at Chigaga in Natete. The evidence is corroborated by the evidence of Kawiye Wudala. PW6 informed the court that on the night of 28th to 29th August 2019 at around 2 a.m. he saw the motor vehicle being parked and abandoned at Chigaga zone. He described the motor vehicle as a white Spacio. From the evidence adduced by the prosecution, I found that there was theft of motor vehicle registration number UBA 570V, and mobile phone is referred to, that is IME number 86295 3044557610. Then cash 260,000 shillings, all belonging to the deceased Maria Nagirinya Gateni. I also find that there was theft of a mobile phone Nokia serial number 356839092092020, and cash 24,000 shillings belonging to Kitaimbwa Ronald. This gradient was therefore proved by the prosecution.
And Counsel Serwanga Geoffrey.